The probate process in 5 steps for California probate properties. That's our topic today. We'll get started right after this. When someone passes away and the decedent, the person that passed away, doesn't have a trust, the California properties and assets must go through a legal process called probate. This includes real property, the home of the loved one that passed away. Welcome back to our channel. Here we talk all about probate and trust administration properties, and especially the real estate involved in a probate or a trust administration in San Diego County. I'm Kim Ward. I am a certified probate real estate advisor and a real estate broker in San Diego. So if you are the executor or administrator of a probate with California probate properties, these are 5 steps through the probate process. Step 1, determine if the estate needs to go through the probate process. Again, if there isn't a trust, or if the California property or properties are not held in a trust, in most cases, the California probate properties must be sold through the probate process. In California, probate is required if the decedent's assets exceed $150,000. And based on that low figure, that means all California probate properties need to go through the probate process. Or if the decedent did not have a valid trust, with one possible exception. So far this year, I've helped 2 clients that thought the property was in the trust, but somehow, well, I won't say somehow, the way it came out of the trust is the decedent refinanced and put some debt onto the property. So in order to do that, they had to take the property out of the trust, the title was taken out of the trust and put into the decedent's name. Now, once the refinance was completed, theoretically, it should have gone back into the trust, but for whatever reason, and banks do this, lenders and banks do this all the time, they don't make sure that the property, the real property, the home of the decedent gets back into the trust. So, all is not lost when that happens. There is a thing, it's called a Heggstad petition. I do believe I have a video on that on my channel. And in most cases, or many cases, a judge will look at the fact that the decedent had planned on having the property in the trust. With my client Ben, he was shocked when we met that the property had been pulled out of the trust. He had no idea. I introduced him to a great attorney that is helping to get the property back into the trust using the Heggstad petition. And that should be done in the next few weeks, and then we can get the house back on the market and Ben can be the trustee of his mother's trust. So for right now, we do have a listing, but theoretically it's not a legal listing because there is nobody who can sell the property because it's not in the trust. So if you have a circumstance like this, be sure to reach out to your local real estate advisor or a good real estate attorney to help you to get the property back into the trust so that it could be sold as easily as possible. Okay, let's continue. Step 2, you're going to want to partner with an experienced probate attorney. Probate can be a complex legal process, so it's important to have an experienced probate attorney to guide you through the legal side of the probate process. Step 3 is you're going to need to file all the necessary documents with the probate court. This includes the will, if there happens to be one, and a petition to start the lengthy probate process. Your probate attorney will handle much of the probate process for you. Step 4 is to notify the decedent's creditors and pay any debts. As the executor or administrator of a probate, it is your responsibility to notify the decedent's creditors. There is a specific way to take care of the obligation, and again, your probate attorney will help you with that. And you will need to address any outstanding debts. And step 5, you'll need to distribute the remaining assets to the beneficiaries. Once all the debts have been paid, you are in the position to distribute the remaining assets to the beneficiaries as outlined in the will or according to California's laws of intestate, which means without a will, intestate succession. Completing these 5 steps will help ensure that the probate process goes smoothly and the decedent's assets, including any California probate properties or the proceeds from the sale of the California probate properties, are properly distributed. It's important to remember to take your time and seek the guidance of an experienced probate attorney. And of course, when it comes time to start the probate process of selling the decedent's California properties, you'll want an experienced probate real estate professional on your team. Hey, thanks for watching. Please like, comment, and subscribe, and I'll see you next week.